Hello, this is Joe Tucker, President of the International Academy of Trial Lawyers, and welcome to Season 2 of The Rule of Law, The Academy Speaks. Today, I am welcoming a very good friend of mine, Jack Scarola, who's an attorney in South Florida. And we're going to be talking about something that's been on the front page, that's been in the news and wherever you look, and that's about Jeffrey Epstein. We've had a lot of people, if you've been watching TV, talking about Epstein and things about that. But Jack actually got to sit across from Epstein to depose him. Jack represented over 20 victims of Epstein's atrocious acts. And we're talking to Jack about a few things as it relates to Epstein and power. First, welcome, Jack. How are you?
I'm well, thank you, Joe, and thank you very much for this opportunity to address a very current and very important topic.
Jack, when is it that you first started in the Epstein files, the Epstein cases? How long ago was that?
It was almost 20 years now, Joe. I began my involvement with representation of individual victims in lawsuits against Jeffrey Epstein in state court in Florida in the 2005-2006 timeframe.
That's quite a long time you've been doing this, Jack, and we appreciate you for your service in doing this.
It must mean I'm very old, Joe.
I don't think you're old now. There have been a lot of people who've been speculating about Epstein, but those people who actually have seen some of the things on TV, you're the lawyer who was deposing Jeffrey Epstein when you were asking him questions about Donald Trump. Is that right?
I am the lawyer whose voice repeatedly has been featured in a variety of broadcasts questioning Jeffrey Epstein, where he has asserted his Fifth Amendment right to remain silent.
All right, we'll get back to that in a moment, but let's talk about some of the ways that the legal system treated Jeffrey Epstein and how it treated his victims. And let's begin with what I'll call, my words, the sweetheart deal he got back in '07. Could you tell us about that and how that came to be?
How it came to be is probably the most important unanswered Jeffrey Epstein related question, Joe, because we know a lot about surrounding circumstances of the sweetheart deal, but why it was entered into and why it was structured in the manner in which it was structured are questions that are answerable, but have never directly been asked of the one person that has the ability to answer those questions, and that's Alex Acosta.
Now, for those people who have heard that name, Alex Acosta, tell us who Alex Acosta was back in '07 and who Alex Acosta became.
Alex Acosta was the U.S. Attorney for the Southern District of Florida, and he was subsequently appointed by Donald Trump to his cabinet in the position of Secretary of Labor. And he resigned from that position largely as a result of the controversy that evolved when his role in the Epstein sweetheart deal became the focus of public attention.
And what was that role that Alex played in the sweetheart deal? And you need to tell the listeners and those people who are watching what the sweetheart deal was and how it arose.
Jeffrey Epstein had been indicted for criminal conduct in the state of Florida. And the fact that criminal prosecution began with an indictment rather than the filing of a direct information was in and of itself unusual. The state attorney, the local prosecutor in Florida, has the authority to direct file criminal charges in all but capital cases. The state attorney chose in this circumstance to bring evidence with respect to Jeffrey Epstein before a grand jury that returned an indictment against Epstein for what many view to be an unusually strange set of criminal charges, because as of the time that that matter was presented to the grand jury, the town of Palm Beach and the Palm Beach County Sheriff's Office investigating.
And that's where Jeffrey was living at the time, correct?
That's correct. He was a resident of the town of Palm Beach. And the principal investigators of Epstein were officers of the town of Palm Beach. And they had identified some 30 victims, some of whom were as young as age 14 when Epstein began his abuse of those children. And many of them were abused on many, many occasions. One of the principal victims, who was 14 years of age at the time that the abuse began, was abused over 100 times by Epstein. So the fact that an indictment was returned based upon the testimony of a single victim and focused on the abuse of that single victim was in and of itself unusual. As a consequence of the failure, unexplained, on the part of the local prosecutor's office to bring more serious and more expansive charges.
When you say more expansive, they could have had other victims testify to bring additional charges, because you said there were 20 or 30 who were known at that time?
There were approximately 30 victims that had been identified as of that time, and a fulsome investigation and prosecution would have extended significantly beyond the single victim that was the focus of the charges that had been filed. The principal law enforcement officer, the chief of police of the town of Palm Beach, was so upset by what went on in that regard that he is the one that went to the federal government. And he said, "This just doesn't make sense to me. You need to get involved. We know that Epstein was involved in transporting children across state lines for purposes of selling them to others. There are federal crimes involved here that need to be investigated."
And that would be sex trafficking.
That would be sex trafficking indeed. And so at the initiative of Chief Ryder of the Palm Beach Police Department, the federal government became involved and began an investigation that resulted in the compilation of a prosecution memo of more than 80 pages in length and a federal indictment of more than 50 pages in length that detailed Epstein's criminal conduct, that identified co-conspirators and laid out a significant series of crimes that the federal government was prepared to prosecute.
Did it identify co-conspirators by name?
It identified some co-conspirators by name. Yes, it did. Now, that prosecution memorandum, despite all statements about a desire for transparency, and that 50-plus page indictment that was never filed, despite all protestations about a desire to be transparent, those documents are in the possession of the Department of Justice. They can be released without permission from anyone. That is, no judge needs to review privilege claims in order to be able to release those documents.
I'm going to ask a question which may sound stupid. Why have those documents not been released to this day, Jack?
That is a very important and unanswered question. So that's one example of how claims of transparency and claims of a desire to achieve transparency clearly have not accomplished, and those claims are false. There has not been an effort at transparency. There has been a deliberate effort for now close to 2 decades of delay and a cover-up. There's no question about the fact that there has been a cover-up. What is being covered up and why remain unanswered questions. But let's get back to the sweetheart deal. The federal government's conducted their investigation. They are prepared to file a 50-page indictment against Jeffrey Epstein. The victims are told in written communications that the federal government is engaged in the prosecution of Jeffrey Epstein, and pursuant to the Crime Victims' Rights Act, federal legislation defining the rights of victims, they are informed that they will be part of this prosecution process. They will be kept informed, and they will have an opportunity to express their views with respect to how this predator is going to be treated by the criminal justice system.
Now, in English, and you help me because I'm not a criminal lawyer, that means nothing substantive is going to happen without letting the victims know what's going on and for their voices to be heard. Is that a fair assessment?
That is a very fair assessment. The Crime Victims' Rights Act is very specific about the rights of victims to be informed of and have an opportunity to participate in every material phase of a criminal prosecution. In spite of that law, in spite of the express promise that was made to the victims that those rights would be afforded to them, the federal government enters into a secret deal, the sweetheart deal, with Jeffrey Epstein. And pursuant to the sweetheart deal, the government gets something. They get an agreement from Epstein that he is going to enter a plea in the still pending state court proceedings that will require Jeffrey Epstein to register as a sex offender. And he is going to serve an 18-month jail sentence.
Now, what type of time was he looking at if they would have prosecuted this case like he was a normal citizen and not wealthy and powerful?
He would have been prosecuted for multiple third-degree felonies, each of which carries a jail sentence of up to 5 years in state prison. So it could have been a very lengthy jail sentence had those times run consecutively, and the court would have had authority to impose consecutive jail sentences for the various crimes that he could have been charged with, but was not.
And this was 2007 when he could have been sentenced to a lengthy jail time.
That's correct. So the federal government enters into this deal with Jeffrey Epstein. The negotiations were directly participated in by Alex Acosta. He was a primary author of this document. And the document included what, from my perspective, was an extraordinary and probably unique provision. Because what the document did was not only agree that Jeffrey Epstein would not be prosecuted by the federal government when they had this 50-page indictment ready to file, but it extended immunity to 3 specifically named co-conspirators of Jeffrey Epstein, and this is the absolutely unbelievable part of the document, all unnamed co-conspirators for any crime that they may have committed up to that point in time.
So hypothetically, all of those people whose names have been mentioned or bandied about, they got immunity.
Including, according to her claim, Ghislaine Maxwell. And that is the subject, the principal subject of Ghislaine Maxwell's currently pending appeal, that she never should have been prosecuted in New York because the U.S. Attorney for the Southern District of Florida granted her immunity that extended not only within his jurisdiction, but throughout the United States.
Jack, I have to go back because one of the issues that the current administration has talked about, and one of the issues that the president talked about, was transparency as it related to the Epstein and what's been termed the Epstein files. And I would be remiss if I didn't say no one has seemed to give a damn about the victims in all of these discussions. But we're going to cover that also probably in a different episode. But that's what infuriates me, that no one gives a damn about the victims.
It was worse than that their interests were neglected. Their interests were betrayed, Joe, because they were told that they were going to be participants in every material stage of this criminal prosecution as guaranteed to them by the Crime Victims' Rights Act. And this is where it becomes even more unbelievable, because at the direction of Alex Acosta, information was not only not conveyed to the victims about what was going on with this non-prosecution agreement, but Acosta agreed with Epstein's defense lawyers that information regarding the non-prosecution agreement would be actively concealed, and was actively concealed from the victims. They were excluded from the process. And what is...
This is outrageous. This is outrageous, Jack. And I know I've heard this before, but to hear someone who was as close to the fire as you and who was a part of the fire say this, it is infuriating.
And it gets worse, because not only were the terms of the non-prosecution agreement actively concealed at Alex Acosta's direction from the victims, the state court trial judge was also purposely, calculatedly kept in the dark.
Now, Jack, you have more gray hairs than me. I suggest you're probably a couple of years older than me. Have you ever seen anything like this in your entire legal career?
The closest that I have ever seen, or heard of for that matter, during the course of a legal practice that's now spanned half a century plus, is there have been occasions where the target of a criminal prosecution, usually an economic crime, has been given the benefit of immunity of a close family member. We won't prosecute your wife who benefited from the economic crime that you committed if you agree to plead guilty to this economic crime.
Like Bernie Madoff.
Like Bernie Madoff. That's a very good example. Yes. Those are circumstances that I have seen before, but I have never seen, and I have never heard of, the federal government or any prosecuting authority entering into an immunity agreement with named and unnamed co-conspirators for unidentified crimes. That just is so absolutely extraordinary, and I suggest unique, and up to this point in time, completely unexplained. And it's not that the answers don't exist. The man who orchestrated this deal,
Alex Acosta,
and the circumstances surrounding its concealment, documented in written memos. It's not like this is speculation. There is an order from a federal district court judge that outlines the documentary evidence of this concealment. That man, Alex Acosta, has the answers. He can tell us why.
Has he ever been questioned about this?
Never seriously and never under oath. During the course of his confirmation hearings, the subject came up. It was not focused upon. Those who were asking the questions didn't have the background information that was needed in order to conduct an appropriate examination of Acosta with regard to these circumstances.
Was he required to disclose those confidential documents in the sweetheart deal that was all a part of the 2007 Jeffrey Epstein plea agreement?
Those documents were obtained in the context of the Crime Victims' Rights Act litigation. And they were not obtained voluntarily. They were not obtained easily. It required court orders to compel the production of those documents. And again, anyone interested in a detailed account of these circumstances can look to the 50-page summary judgment order entered by Judge Kenneth Mara, Federal District Court Judge Kenneth Mara, that describes and directly quotes from all of these highly incriminating documents and talks about private breakfast meetings outside the U.S. Attorney's Office between Acosta and Jeffrey Epstein's, one of many of Jeffrey Epstein's criminal defense lawyers.
What criminal defense lawyer wouldn't want that type of relationship with the U.S. attorney?
Yeah. Why they had that kind of access, why these meetings are taking place outside the office of the U.S. attorney, what went on, those are questions that need to be answered in light of the seriousness of all of these circumstances. And the questions have never been appropriately asked, and they clearly have never been properly answered under oath as they need to be put and responded to. It has happened, and there's no good explanation as to why.
I have so many things I want to cover with you. I'm still on 2007, and I apologize. What was the result of his sweetheart deal as related to time served and how he served his time?
Jeffrey Epstein's time was not served in a state prison. It was served in a local detention facility. There was a wing of this particular facility that was not in use at the time, that was expressly furnished for Epstein so as to make.
Jack, how the hell does he get that? What? I mean, I know he got the sweetheart deal, but how the hell does he get his own furnished wing, not in prison, but in a county detention center? This, I keep using the word outrageous. This is ridiculous, Jack. How did he get that?
Well, it gets even more ridiculous, Joe, because within a very short period of time, although sex offenders under Florida law are generally not eligible for work release, Jeffrey Epstein is placed on a work release program. And Jeffrey Epstein's work release program consists of his being transported by limousine.
Of course, because that's the way we transport prisoners.
From his comfortable accommodations to a private office in downtown West Palm Beach that has been set up for the private charity that Jeffrey Epstein has created in order to give himself a job. He is guarded by off-duty Palm Beach County Sheriff's officers who are instructed to avoid embarrassing Jeffrey Epstein by providing their services while in uniform. They have got to dress in civilian clothes.
Jack, there's been a suggestion that during this, and I'm putting this in air quotes, work release that Jeffrey got as part of his sweetheart deal, that he continued being a sexual predator. There have been suggestions and rumors about that. Do you know anything about that?
What I can tell you is that I have not seen direct evidence that that occurred. I can tell you that there are visitors' logs that are incomplete, that there are circumstances that exist that suggest that that could have occurred, but I haven't seen direct evidence that it did occur, nor have I spoken to anyone, to any victim who says that she visited Jeffrey Epstein under the circumstances that I have just described. Is it possible? It is clearly possible. Given Epstein's proclivities and knowing what Jeffrey Epstein's money did buy, it becomes likely that he continued his abuse of children even while he was in custody.
And clearly in the realm of possibility. I know that a good friend of ours who recently passed represented a number of victims who are not publicly known and whose stories have not been publicly known. Have any of them come forward to talk about other people who may have molested and sexually assaulted them other than Jeffrey Epstein?
There have been Epstein victims who have named other individuals to whom they were provided by Epstein.
That was just the first part of our 3-part interview with Jack Scarola, Season 2, Episode 1. Catch us on the next 2. Looking forward to talking to you again. I'm Joe Tucker, President of the International Academy of Trial Lawyers, and this is the rule of law the Academy speaks.